Welcome to the Western PA Work Injury Podcast.
Welcome to the Western Pennsylvania Work Injury Podcast with attorney Mike Russell. With 33 years of experience representing injured workers across Western Pennsylvania, Mike focuses on helping clients navigate workers' compensation claims and protect their income and benefits after a workplace injury. I'm Lisa Mosbey, and today we're talking about whether you can choose your own doctor under Pennsylvania workers' compensation and what injured workers need to know before making that decision. Mike, welcome back.
Pleasure to be here, Lisa.
We touched on this a little bit in the last episode, but today we get to go a little bit deeper. In Pennsylvania workers' compensation cases, are injured workers required to see certain doctors at the beginning of the claim?
Yes, they are, Lisa. We have a practice or a procedure in Pennsylvania that's put in place by the statute that limits an individual injured at work. It limits his ability to seek medical treatment with his own physician for a limited period of time. It's called a panel physician system. I mean, that's what I would call it. But in essence, when an injury is accepted, now we'll take a little sidecar here. If the claim is denied in that first few weeks or first month or so, once that claim is denied, the employee's obligation to seek treatment with a physician on that panel list ends. And at that point, they are free to seek treatment with anybody they so choose. If we, however, assume that a claim has been accepted by a carrier in one of a couple of different ways, there can be a partial or a full acceptance, but let's just assume the claim is accepted. At that point, under some limited circumstances, an employee is required to treat with somebody on what is called the panel list of physicians. There are some requirements that the employer has to meet in order to obligate that individual to follow that process. They have to have a panel. There are quite a few employers that don't have panels. In fact, I'd probably say, I've never looked at the numbers, but I'd venture a guess that probably 25% of the employers have panels and the rest don't. So a panel list is a list of physicians, typically 4 or 5 different physicians in certain different specialties, so they can cover kind of what they would expect to have in terms of needed treatment. They have to have you sign that list when you get hired. When you have an injury, it is the employer's obligation to then provide that list to the injured worker as soon as practical after the accident. So they've got to give it pretty quickly. And it's also a requirement that they post it in a position or in a place where the employee's often frequent, so that there's some realistic understanding on the employee's part that they are limited in their treatment. Assuming the employer follows all of those technical requirements, then in fact, if they have accepted and begun to pay either medical or wage and medical, then for that first 90 days, the employee is obligated to see somebody on that list. Obviously, things change. If you get referred to somebody off, there's some things that can happen. I talked in a prior episode about second opinions. You are entitled to get second opinions. You can go back to episode 2, I think it was, and we talked a little bit about getting second opinions. But that's the structure of the system. So indeed, you have to treat with their panel physicians. One of the issues that we're facing a lot over, I guess, probably 15 years, maybe longer. Time flies when you're having fun, Lisa. But what we're seeing is a number of managed care facilities that are basically a location that has a couple of on-staff doctors, but then they have other doctors that are somehow affiliated. So an employer might give you a panel list that has one managed care facility on its panel. I don't consider that a panel. And in my honest opinion, an employee can say, I'm not going to that facility. I'm going to go find another doctor. The unfortunate reality of that is there's a risk to that. And I'm hard pressed to tell a client, look, that in my opinion doesn't constitute a panel. You can go see your own doctor, because the practical matter here is if you don't see that panel physician, there are consequences. And so 99% of the time, we're going to take that first 90 days and allow my client to treat with the panel until we can get to that point that either the claim is denied or the case is in a position that they're beyond 90 days and we can get them to see their own physicians.
You already answered my question. My next question is what happens? How do they get to see that second one? But they really need to fulfill their obligation to the panel, and then that second opinion and those other doctors are available. What happens if an employer doesn't follow the proper rules for setting up or maintaining a panel of physicians?
I'll answer that question two ways. I'll jump back a little bit. I mentioned consequences, and the consequences for a claimant, the injured worker, we call them claimants in our state. If that claimant doesn't follow the procedure and decides, I don't like that doctor I saw over at that panel, I'm going to go to a doctor of my own choosing, and the employer has accepted the claim, the reality is for that injured worker that they are now subject to payment of the bills on their own. They're coming out of their own pocket. So the problem is if you choose as an injured worker to seek treatment off of your panel, you face a significant consequence because work comp doesn't have to pay it under the statute. And number two, since it's a recognized claim, I can't argue to your health insurance that they should pay it. Flip side of that coin is the employer does have obligations. They have obligations to do the things that we've talked about. They have an obligation to have you sign it. Oftentimes that doesn't happen. They have an obligation to post it. Sometimes that happens, and sometimes you might have as an example, I have cases where people are traveling nurses. They're going to people's homes. So they don't show up at work every day and go into the break room. They're at this house and then a house over there and some other house. So they're not anywhere where they can see that post. So then that becomes an issue. So typically what I'm looking for as an attorney, those first two are important. I'm not minimizing the importance of those, but the most important of those three steps for me is that when my client has an injury, I expect them to receive a copy of a list of physicians that they can choose from. If they don't receive that, then I'm going to assume that the first two weren't done. And I think that's kind of the most critical one, because if you have an injury and you're supposed to treat with one of their doctors, well, the act doesn't say any of them is more important. For me as an attorney, if my client gets a panel list, I'm going to recommend that they treat on that panel list for the first 90 days, because I don't want a client who, as we've talked about before, is already having difficulty paying bills, now getting a bill for a $300 office visit with an orthopedic because they chose to treat with somebody off the panel. So that's kind of the lay of the land that we deal with on those panel lists.
And then Mike, after the required period ends, those, let's say 90 days, I believe you said, what options does someone have to choose their own doctor? And is that covered by the employer, or then they start to absorb the costs from that point on until they settle the claim?
Now, again, we're going to assume that a claim has been accepted. I've already indicated if the claim's denied, they get to go anywhere they want. Hopefully, they've had a lawyer involved, they've got their insurance set up, and they've got other insurance to pay until we can fight the case. But assuming the claim has been recognized, there's some complications there. They can issue a document where they accept the medical, but they don't accept the wage. That still ties my client into 90 days, even though they're not getting paid, which can sometimes be very, very problematic. But once we get beyond that 90 days, then assuming the claim has been accepted, that employee is free to treat with any physician of their choosing. One of the things that people do is don't do that, and they just continue to treat in that panel group. And maybe we'll delve into that at a later point. But um, they need to start seeing somebody on their own. As an attorney that's practiced in this field, well, I wouldn't say it as a 100% principle, so to speak. There are some of these providers that we know are very, very apt to put somebody back to work who realistically isn't capable. So we need, at the expiration of that 90 days, to get into treatment with somebody we know is going to be on our side.
And that makes complete sense. How can the choice of doctor affect the strength or the direction of the workers' compensation case?
Of all the things I could talk about, I would probably say that's the most critical. Um, I've practiced for 33 years. I've seen most physicians. I've seen probably, being how old I am now, I'm seeing some new doctors come in that I haven't met yet, but most of the orthopedics in Western Pennsylvania I've met at one point or another, and I know. So, in the context of a workers' compensation claim, one of the things that happens immediately after the first hearing is the employer gets an independent medical examination. That means they send my client to somebody of their choosing who is not for purposes of treatment, but is simply what I would suggest is a medical legal consult. So they're going to have a doctor more than likely on their side. Now they might help us, they might not, but we'll talk about that maybe some point later. Um, so the requirement that you have a physician that is willing to treat you and fight for you is beyond critical. And if you have an attorney involved at the outset of your claim, and you have an attorney who has seasoned and done this for a while, they're going to know the physicians that are available for you to see. Again, I pride myself on not referring every client out to a doctor that I think's going to help. But I also know, and I had a case very, very recently, a returning client that I represented on a prior injury, just thought about this young man who had a pretty catastrophic injury, which fractured a fracture on his arm that he had in a motor vehicle accident, went back to work and broke it again. Um, Retains me, we file a petition, and his doctor won't testify. His doctor will not get involved in the claim, will not write us a report to tell us whether this guy's condition relates to the old injury or the new injury, the accident in the car or the accident at work. And the unfortunate reality for him at that point is I can't do anything for him because without that expert who is treating you, and we want good treatment. I've already said in past episodes, my goal is for people to get back to work, but we need a doctor who's going to treat you, but is also willing to fight to help you in litigation, to testify on your behalf. And there's good doctors that can testify, and there's doctors that have testified the first time and don't do a very good job because they're not used to the nuances of what we lawyers have to deal with. Doctor choice is critical.
Mike, that like puts people in such a tough situation. This young man that you're talking about, how did he know he picked a bad doctor? What are some of the common, not a bad doctor, but somebody who wouldn't fight for him? Because obviously he treated him and he repaired the arm, but some common mistakes, that people make when it comes to choosing doctors. What are they and how can we avoid them?
Well, I touched on one earlier, and we've kind of talked in summary around some of these issues. Number one, don't treat with a panel physician any longer than you have to. Um, I had a case recently where I told my client to quit going to the panel physician. She went to the doctor that I got her to. He said, "You can't work." Went back to the panel physician a couple of weeks later to my utter dismay. And the panel physician said, "Oh, you're fine. You can go back to work full duty." So she implicitly created a conflict in her own case between the doctor that had treated her for that point up to that point and the good. And it's not, I don't want to say good because some of these panel physicians and some of these IME physicians are fantastic. I had one of them do surgery on my foot, but it's just a question of sometimes of the mentality of that physician or that physician's willingness to fight. And so harping on the same thing, get a lawyer who is seasoned in the practice of workers' comp, who knows the doctors. And if you're seeing a doctor like uh, one of the ones I could probably mention, I might think he's a great doctor, but I'm going to say, look, I already know this doctor is not going to testify. You
Right.
need to go somewhere else. We need to get you away from that doctor so that we can get you into somebody who's going to treat you and fight for you. So get out from under that panel in 90 days. Get to your primary care physician. That's where I typically start. My goal would be to have the panel or the primary care physician refer my client to somebody that they trust. But then I tell my clients always check with me because I know them all, and then get to a specialist. Clients will come to me after 6, 9, 12 months plus treating with nobody other than the family physician, who treats colds, flus, and foot fungus and cannot win a workers' compensation claim. So we need to get them to somebody who's going to be a specialist in that field. And there's some specialists that might do knees and shoulders. If I have a shoulder condition, I want you to go to somebody that does only shoulders, that is well versed in that practice.
And Mike, if there's a disagreement about medical treatment or doctor choice, what is the process for resolving that?
Court, it's litigation. As I think I said at some point in one of these, and maybe even this one, I have many, many cases over here, and in every single one of them, I have a doctor on my side helping us. I have a doctor on their side against us. If it's not that case, then they're not here. Then we're not in court. So we fight over whether conditions are related. We fight over whether it's necessary treatment. We fight over whether or not the condition impairs an individual's ability to work. Those fights exist, or I'm not going to court. And I know in those cases, I've got doctors on each side of the fence that are saying, quite frankly, diametrically opposed opinions sometimes. I mean, as far on the two ends of the perspective and spectrum of that case as you could possibly imagine. Clients don't understand how, but doctors can render an opinion. One doctor can look at it and say it's not work-related because of ABC, and the other looks at it and says it is work-related. We fight those things in court day in, day out, 5 days a week, 52 weeks a year.
Mike, thanks for your insights today. I appreciate your knowledge in helping people walk through this process and really understand those minute details, and then your patience to get someone from start to finish through this process. So thank you for sharing your experience.
Thank you. It's been my pleasure.
That's it for today's episode of Western PA Work Injury Podcast. If you have questions about your medical treatment options or your rights under Pennsylvania workers' compensation, you can learn more or get in touch with attorney Mike Russell at attorneymichaelrussell.com. Thank you so much for listening. And don't forget to subscribe, share, and leave us a review. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.